There is a moment I keep coming back to, and I want you to picture it with me. A man standing at the end of a driveway looking at a house he built with his own hands, a house that holds every memory of the woman he loved and lost, and he cannot make himself walk to the front door. Not because he is weak, because someone else has made him feel like a stranger on his own land. That man is me, and I am here to tell you exactly how it happened and exactly how it ended. It started with a phone call. My son crying, his wife pleading. They had nothing left, they said. Nowhere to go. And because I am the kind of person who believes that family shows up when it matters, I opened the door. I handed them the keys to the one place in this world I had left to hold on to. I asked for almost nothing in return. What I got back was a daughter-in-law who looked me in the eye and told me the house was hers now, and I should get used to it. What I did next, she never saw coming. Because what she did not know, what none of them knew, was that I had been watching, writing, and building something of my own the entire time. Not with lumber and wire, with dates, documents, and patience. Stay with me all the way to the end. This story has layers she spent months carefully hiding, and every single one of them came out in the light. I promise you, the ending will leave you with exactly the feeling she never thought I was capable of delivering. My name is Warren Holloway. I am 66 years old, a retired electrician who spent 4 decades working with his hands in Central Florida, wiring homes and commercial buildings from the ground up. And for most of those years, I did it alongside a life that felt, most days, like more than a man like me deserved. My wife Vera passed 2 years ago, and since then I have been learning slowly, and not always gracefully, how to fill the hours she used to fill just by being in them. The cottage was the last thing we built together. Not built with my hands alone, though. I did most of the physical work across 3 years of weekends and vacations. Built together the way you build something with a person you have shared your life with, every decision made in conversation, every choice carrying the weight of both of you. Vera picked the porch width because she wanted 2 rocking chairs side by side with enough room between them that you didn't have to hold your arms in. She chose the kitchen window placement because she said the morning light in that corner of the lot was different from anywhere else on the property, softer, the kind of light that didn't demand anything from you. I trusted her on things like that. She was almost always right. We always said that when I finally hung up my tools for good, that cottage would be where we landed. 3 rooms, a wide front porch facing east, 40-something acres of quiet Florida land rolling out behind it. That was the plan. That was what the plan looked like when we made it together. Then Vera got sick, and the plan became something I carried alone, and I kept carrying it because putting it down felt like losing her a second time. I had been living in the cottage full-time for about 8 months by the time the phone call came. Not quite retired yet, still taking small consulting jobs here and there, but close enough to feel it. I was in a good place, or as good a place as a man gets when the person he built everything with is no longer there to share it. I had her garden going again in the side yard. I had her photographs back on the walls where they belonged. I was sleeping through the night most nights. That counts for something. The call came on a Thursday evening in January. It was Gavin. My son is 37 years old, and I had not heard him cry since he was a teenager, so when the sound came through the phone, I sat down before I knew I was sitting. He had lost his job 3 months earlier and had not told me. The debt had accumulated quietly, and then, all at once, he and Sabrina and their daughter Tessa were facing eviction from their apartment in less than 60 days, and he had no plan, no cushion, and nowhere left to turn. He said he was sorry. He said it more than once. I told him to stop apologizing and tell me what he needed. That was when Sabrina got on the phone. Her voice was softer than I expected, careful, like someone choosing each word before it left her mouth. She said they were not asking for money. She said they just needed a place to land while they got back on their feet, just a few months, just long enough for Gavin to find steady work again. She said the word family 3 times in under a minute, and I noticed that the way you notice something without knowing yet what it means. Then she said the thing that I would think about later, much later, when I understood more than I did in that moment. She did not say somewhere to stay. She did not say any of your properties or wherever you think makes sense. She said specifically and without hesitation the cottage. That one, the one Vera and I built. I told myself she had probably just heard Gavin mention it. I told myself it was a natural thing to say. I let it go. I set the rent at $850 a month. The market rate for that property was closer to $1,700. I knew that. I did it deliberately because this was my son, and because I thought of it as a gift with a return date, and because I did not yet understand the difference between generosity and exposure. I did not draw up a lease. A written agreement between a father and his son felt like an insult to something I still believed in. That belief would cost me more than I had any way of calculating that January evening. 3 weeks later, I drove past the cottage on my way back from a supply run. I slowed down without meaning to. There, on the front porch, post-mounted cleanly and stained to match the wood, was a sign I had not seen before and had not been asked about. It read, "The Holloways," not my name. Gavin's family name, presented as though the house had always been theirs, as though I had never existed in it at all. The sign stayed with me longer than I expected it to. I did not stop the truck that afternoon. I slowed, registered what I was seeing, and kept driving, because pulling over in front of my own property to stare at a piece of wood felt like a concession I was not willing to make before I understood what I was conceding to. But the image of it settled into a part of my mind that does not let things go easily. And over the following days I found myself returning to it the way you return to a detail on a job that does not quite add up. Not with alarm, not yet, but with the specific attention of a man who has learned through long experience that small things that feel wrong usually feel that way for a reason. I went back to the cottage twice in the 3 weeks that followed. The first visit, I told myself, was routine, that I had left a set of spare electrical connectors in the storage cabinet off the laundry room and needed to retrieve them for a small consulting job I was finishing up. That was true. It was also true that I wanted to see the interior, to take the measure of how things stood inside the same walls where Vera and I had spent 3 years making every decision by hand. Sabrina met me at the door with the version of herself she always presented when she was expecting to be observed: pleasant, organized, slightly performative in her warmth. She offered coffee. I declined and explained what I had come for. She led me to the laundry room, waited while I found the connectors, and walked me back to the front door with the efficiency of someone who had timed the visit to be exactly as long as it needed to be, and not a moment longer. It was enough time to see what I needed to see. The living room had been rearranged completely, not renovated, nothing structurally altered, but every piece of furniture Vera and I had selected together had been replaced with pieces I did not recognize. Lighter in color, more contemporary in style, the kind of furnishings that photograph well for an audience that is not standing in the room. The walls were different. Vera's photographs, the ones she had chosen and framed herself. The wedding portrait above the mantel. Her garden series along the hallway. The black and white landscape she had found at an estate sale in Ocala, and loved for reasons she could never quite articulate, were gone. In their place were prints in matching frames, the kind that come as a coordinated set. I noted it and said nothing, and drove home with the connectors and the particular feeling of a man who has just seen something he cannot unsee. The second visit came 2 weeks after that, unannounced, which in retrospect I understood was necessary if I wanted to see anything that had not been staged for my benefit. I told myself I was checking on a small roof repair I had made the previous autumn, which needed to be examined after the spring rain we had gotten. That was also true. Gavin answered the door this time, and there was a moment before he arranged his expression where I could see that my arrival was not entirely welcome, which told me something. He let me through to the side yard to check the repair, which was holding fine, and I was making my way back around the exterior when I noticed something I had not seen on the previous visit. A small stack of boxes near the basement entrance, partially covered with a tarp, the kind of boxes you use when you are moving things you do not want to display but are not ready to discard. One of them had slipped partially open, and visible through the gap was the corner of Vera's wedding portrait. The frame I had bought at a shop in Tampa, the year we married, dark walnut hand-fitted glass. I did not open the box. I did not take the portrait. I stood there for a moment, and then I continued around to the front of the house. Gavin was waiting near the door, and before I could say anything about what I had seen, he told me in the slightly practiced way of someone relaying information they have been given, rather than information they have decided, that the utilities had been transferred into his name for billing convenience, that Tessa had been enrolled in the local school using the cottage address, and that the neighbors had been very welcoming. He said the last part as though it were a point in his favor. I was preparing to leave when I noticed Tessa sitting on the porch step with a book in her lap, reading in the way that children read when they are trying to make themselves small in a space where adult things are happening. I recognized the book before I was close enough to read its title. It was Vera's garden reference book, the one with the broken spine that she had repaired with tape 3 times rather than replace. Because she had made notes in the margins across 15 years, and the notes were the point. I stopped and looked at Tessa and asked her where she had found it. She looked up at me with the careful eyes of a child who has learned to measure a room before she speaks in it, and she said she had found it in one of the boxes and put it on the shelf so it would not get thrown away. She said it like it was a small thing. It was not a small thing. I thanked her and walked to my truck, and that was when Sabrina appeared on the porch, unhurried, as though she had been waiting for the correct moment to step into the scene. She called after me in a voice that was pleasant enough on the surface that someone passing by would not have heard the current running beneath it. She said she just wanted to mention as a friendly heads up that she thought I should be careful about how I came across to people in the area. She said I did not want to seem difficult. Then she smiled and went back inside, and I heard the screen door close behind her with a sound that was almost polite. The drive home from the cottage that afternoon took 11 minutes. I know because I watched the clock on the dashboard the entire way, not tracking time so much as giving my hands something to do besides grip the wheel until my knuckles went white. Sabrina's parting words were still sitting in my chest, not because they frightened me exactly, but because of the way she had delivered them. Calm, pleasant, almost like a woman reminding a neighbor to keep his dog off her lawn. You don't want to seem difficult. I had been on job sites for 4 decades. I knew what it looked like when someone established territory. I had just never expected to see it done on my own porch. I sat in my driveway for a while after I pulled in. Not paralyzed, not panicking, but thinking the way I used to think when a project came in wrong and I had to figure out where the problem started before I could fix anything. Something had shifted in the past few weeks. I could feel it the way you feel a change in weather before it arrives, that particular pressure in the air. I had been going over to the cottage and coming back unsettled, and I had been treating that unsettled feeling like something to manage rather than something to act on. That was a mistake I recognized in myself. I had spent 2 years managing things quietly since Vera died, absorbing difficulty and calling it strength. But there is a difference between patience and passivity, and I had been standing too close to the wrong side of that line. I went inside and found what I was looking for in the cabinet beside the back door, a wide-ruled notebook, the kind with the black and white speckled cover, the same kind I had used on every major job for 30 years. I used to keep 3 or 4 of them going at a time, one for each site, logging everything that happened, every material delivery, every conversation with a subcontractor, every deviation from the original plan. If something went wrong on a job and someone needed to know the sequence of events, I could hand them the notebook and every answer was in there with a date beside it. I sat down at the kitchen table and I opened a fresh one to the first page and I wrote the date at the top. Then I started writing. I wrote everything I could remember from the beginning, the phone call in January, the specific words Sabrina had used, the rent amount we had agreed to, the fact that we had not signed anything. I wrote down every visit I had made to the cottage since they moved in, and what I had observed on each one, the sign on the porch post, the utility notices with Gavin's name on them, the boxes of Vera's things in the basement, the way the kitchen had been rearranged, the new decor where her photographs used to be. I wrote down what Tessa had said to me about the garden book with the date and the time of day. I remembered it. I wrote down Sabrina's exact words from that afternoon, the ones about being careful how I came across to people. I wrote them inside quotation marks and I underlined them once. Then I picked up my phone and went back through every text message Gavin and Sabrina had sent me since January. There were not many. I took screenshots of every single one and emailed them to myself with a subject line that included the date. After that, I opened Sabrina's social media page, which I had looked at once before without thinking much of it. I looked at it more carefully this time. There were 14 posts that featured the cottage, some with photographs of the exterior, some with interior shots of the kitchen and the living room she had redecorated. The captions described the property as their home. One of them used the phrase, "our little piece of paradise." I screenshotted each post, including the dates they were published, and emailed those to myself as well. I did this without any particular anger. I did it the way you document a job site, because documentation is what stands between you and someone else's version of what happened. The next morning, I drove over to Marlene Dutton's place. Marlene is 63, a retired school administrator who lives about a quarter-mile from my main house and who has been a steady, sensible presence in my life since long before Vera passed. She is not the kind of woman who offers comfort before she offers clarity, which is exactly why I trusted her. I told her what had been happening starting from the phone call and moving forward in order the same way I had written it in the notebook. She listened without interrupting, which is one of the things I have always valued about her. When I finished, she was quiet for a moment, then she said, "Keep every scrap of paper, Warren. Every single one." I told her that was already underway. She nodded like that was the correct answer. That afternoon I called a local property attorney whose name I had gotten from a flyer at the county building some months back, and whose office had a reasonable voicemail message. I explained my situation briefly and scheduled a consultation for the following week. When I sat down across from him and laid out the basic facts, he listened, made a few notes, and then looked at me across the desk and said something I had not been prepared to hear, stated quite so plainly. He said that without a written lease, what I had created was a month-to-month tenancy with full legal protections on their side. He said I would need to serve a formal written notice before any further action was possible, and that the process from there would not be quick. He said all of this in the patient, unhurried tone of someone delivering information to a person who is only now beginning to understand the shape of the problem they are in. I drove home with both hands on the wheel and one question turning slowly in the back of my mind: had I already, without meaning to, handed them something I was going to have a very hard time getting back? The week between the attorney consultation and my next visit to the cottage was one of the quieter weeks I had spent in some time, and I do not mean that as a compliment. It was the kind of quiet that comes not from peace, but from a decision already made and not yet executed, the waiting period between understanding what needs to happen and making yourself go do it. I had the notice prepared. I had reviewed it twice with my attorney by phone. It was not a legal document, yet not a formal filing. Just a written statement of my intent delivered in person, face to face, the way I had always preferred to handle difficult conversations in my life. I had delivered hard news to subcontractors, to clients who were not going to get what they wanted, to suppliers who had fallen short. I was not unfamiliar with the experience of saying something a person did not want to hear and holding your position while they processed it. I told myself this was not different. I was wrong about that, but I did not know it yet when I pulled into the cottage driveway on a Tuesday morning in March. Gavin answered the door. He was in a work shirt I did not recognize, casual like he had nowhere particular to be, and when he saw me standing there, something in his face arranged itself carefully the way a person's face arranges itself when they have been expecting a conversation they are not ready to have. I told him good morning. He said good morning back. I asked if we could talk inside, and he stepped aside to let me in without saying yes or no, which was itself an answer of a kind. The living room looked the same as it had on my last visit. Sabrina's furniture arranged in the space where Vera's used to be, the walls carrying photographs I did not recognize of people I had never met. I sat down in the chair nearest the door, and Gavin sat across from me, and I said what I had come to say plainly and without softening it past the point of clarity. I told him I needed the cottage back. I told him I was planning to move in by fall, that my intention had always been to live there myself, and that I was giving him formal notice of 90 days to make other arrangements. I told him I would help him however I reasonably could in making that transition happen. He looked at the floor for a long time after I finished. Not at me, not at the wall, at the floor, in the specific way that a man looks at the floor when he is working out what someone else has told him to say. Then Sabrina walked in from the hallway. I do not know if she had been listening from another room or if the timing was coincidental, but something changed in the air the moment she entered it. The version of Sabrina I had encountered before, the careful one, the one who chose her words and smiled at the right moments and kept her edges hidden, stepped back, and what replaced it was quieter and in some ways more unsettling precisely because of how quiet it was. She did not raise her voice. She sat down on the arm of the sofa, crossed her arms loosely, and looked at me with the expression of someone reviewing a situation they have already thoroughly analyzed. Then she said, "Warren, I think you should speak with our attorney before you come here again. We have rights in this property. We are not going anywhere." I had not known there was an attorney. The word landed differently than she may have intended it to because it told me something she had not meant to tell me, which was that this moment had been anticipated and prepared for. I kept my face still. I told her I would be filing a formal notice to vacate through the appropriate legal channels and that my attorney would be in contact. She nodded in that same measured way and stood, and walked me toward the front door, as though she were a host concluding a visit that had run slightly long. On the threshold she paused, and she said with the door half open and the morning light coming in around her, "You might want to think about how this looks." An old man pushing his family out onto the street. She said it gently, almost helpfully, and then she closed the door, and I was standing on the porch of my own cottage, listening to the latch click into place on the other side. I sat in my truck in the driveway for several minutes before I started the engine. I was not angry, or not only angry, I was recalibrating the way you recalibrate when the job in front of you turns out to be more involved than the initial assessment suggested. I called Marlene from the driveway before I pulled out. I told her what had happened, the attorney comment, the way Sabrina had handled it, the door closing. Marlene was quiet for a beat, and then she said she came prepared, Warren. That was not a reaction. She has been waiting for you to say exactly that. I sat with that for a moment, then thanked her and drove home. That evening my phone rang. It was Dale, the neighbor, 2 houses down from the cottage, who had known Vera from the early years, and who had offered to write a character statement on my behalf when the situation first began to surface publicly. He said he wanted me to know something he had seen that afternoon after I left. Sabrina had been in the front yard about an hour after my truck pulled out, on her phone laughing. He had not been trying to listen, but she had not been trying to be quiet either. And what he heard her say clearly enough that there was no mistaking it was this: he will file, and when he does, we will be ready. Dale's words stayed with me through the rest of that evening and into the following morning. He will file, and when he does, we will be ready. I turned the sentence over the way you turn a piece of material over in your hand when you are trying to understand its weight before you commit to using it. She was not afraid of the process. That was what the sentence told me. She had studied the process, whatever version of it she imagined was coming, and she had made her preparations in advance. And she was waiting on the other side of it with something she intended to use. That kind of confidence does not come from nothing. It comes from research or from counsel, or from prior experience with a situation that resembles the current one. I wrote the sentence in my notebook that night, attributed to Dale, with the date, and I underlined it the same way I had underlined Sabrina's words from the porch. Then I called my attorney first thing the next morning and told him we needed to move faster than we had discussed. The formal notice to vacate was served by a process server on a Thursday. I paid for the service myself, rather than attempting to hand-deliver another document to that front door. The process server confirmed receipt, got a signature, and sent me the paperwork the same day. I filed everything in the accordion folder I had started keeping specifically for the cottage situation, organized by date, with copies made and stored separately. My attorney had advised 60 days notice given the informal nature of the original arrangement, and we had built in that buffer carefully. The clock was running. I told myself that was something. The response came 11 days later. Not from Gavin, not by phone, but in the form of a letter from Sabrina's attorney, which arrived at my main house address and which I read standing at the kitchen counter without sitting down first. The letter stated that my tenants were disputing the notice to vacate on the grounds of uninhabitable conditions, specifically the presence of mold in the primary bathroom, which they claimed had caused ongoing health concerns for the family, and which they argued represented a failure of my obligations as a landlord. Attached to the letter were 3 photographs and a 1-page assessment from a contractor whose name I did not recognize. I set the letter down on the counter and stood there for a moment. Then I read it again from the beginning. The mold claim was false. I knew it was false because I had built that bathroom myself, and I knew every inch of its construction. The ventilation, the tile work, the grout ceiling, I had redone less than 4 years earlier. But knowing something is false and proving it in a way a court will accept are 2 different problems, and Sabrina had clearly spent some time thinking about that distinction. I contacted my own contractor, a man named Gerald who had worked with me on and off for 15 years and whose word I would have put against anyone's, and he went through the cottage bathroom with a moisture meter and a detailed eye and found nothing that qualified as an active mold problem. He wrote it up in a formal report with photographs and measurements and signed his name to it. I submitted that report to my attorney the same afternoon I received it. What happened next was the part that tried my patience more than almost anything else in the months that followed. The court, facing two contractor reports that directly contradicted each other, ordered an independent inspection by a neutral third-party assessor. Until that inspection was completed and its findings submitted, the eviction proceeding would be paused. My attorney explained this to me in the careful tone of someone who has delivered this kind of news before and knows there is no version of it that feels acceptable. I told him I understood. I went home and wrote the word "stalled" in my notebook, with the date beside it and a line under it. While the legal process was sitting still, Sabrina was not. I began hearing things from the edges of the community around the cottage, the kind of information that travels through neighborhood groups and church parking lots and the waiting areas of local businesses. The story she was telling was consistent, and it was effective. A landlord who had given them a place to stay was now trying to push them out without cause. A young family with a child, a woman just trying to hold things together. She never used my name in the version that reached me secondhand, but the description was specific enough that anyone who knew the situation could fill it in without difficulty. Most people in that immediate neighborhood did not know me. They knew what Sabrina had told them, and she had told them first. Dale called again during that period, not with new information this time, but simply to tell me that he was still on my side, that he remembered who I was and who Vera had been in that community, and that he had already put his character statement in writing and was prepared to submit it whenever I needed it. It was a small thing measured against the size of what was moving against me at that moment. But small things done with genuine intention have a weight that is disproportionate to their size, and I told Dale that and meant it. I was reviewing my personal documents one evening, about a week after the independent inspection was ordered, when I noticed something I had not caught before. I pulled up my mail forwarding records, the account I had set up through the Postal Service when I first transitioned from full-time work to consulting, and I went through the delivery log more carefully than I had before. Several pieces of correspondence, financial documents addressed specifically to me at my personal accounts, had been delivered not to my main house but to the cottage address. I had not authorized any forwarding to that location. I sat with that for a long time, going over the dates, checking the account settings, looking for any change request I might have submitted and forgotten. There was none. Someone had redirected my mail to that address, and it had not been me. I did not sleep well that night. Not because the mail forwarding discovery frightened me in any immediate sense, but because of what it implied about timing. The change had not happened after I served the notice to vacate. It had not happened after the confrontation in the living room, or after Sabrina mentioned her attorney, or after any of the moments I had already identified as turning points in what was happening between us. When I cross-referenced the delivery dates against my own calendar, the redirection had begun in the second week after they moved in. That was January. That was before any friction, before any notice, before I had done or said anything that could have prompted a defensive response. Someone had changed the destination of my personal financial mail within days of arriving at that cottage, at a point when everything between us was still cordial on the surface, and I was still telling myself this was a temporary arrangement between a father and his son. I wrote the dates in my notebook in a column, drew a line under them, and sat at my kitchen table until the sky outside started to lighten. The first thing I did that morning was call Marlene. I did not want to process what I had found alone, and Marlene had earned the right to be in this with me through months of steady, practical support that she had offered without being asked and without requiring anything in return. She came over within the hour, and I walked her through the delivery records at the kitchen table, pointing out each date, each document type, each address discrepancy. She looked at it all carefully, without speaking, in the focused way she used to review student records when she was still working, and when she finished, she sat back and said she thought we needed to start talking about what kind of person actually plans something like this before they even unpack their bags. I told her I had been thinking about exactly that since 3 a.m. She said she had a few things to show me as well. Marlene had been doing her own research in the weeks since I first told her what was happening, the kind of patient, organized research that her years in administration had made second nature to her. She had pulled the public court records for the county where Sabrina had lived before she and Gavin moved to Florida, searching for civil filings under her name. What she found was not a conviction, not a judgment, nothing that explicit. What she found was a civil case from 6 years earlier. A landlord filing and then withdrawing an eviction claim with a notation in the record suggesting the matter had been resolved privately. She had no way of knowing the terms, But the pattern was recognizable, and she said so plainly. Then she told me she had been thinking about someone I should speak with, an attorney in Gainesville named Elias Boone who specialized in property fraud and financial exploitation involving older adults. A man from her church had worked with him the previous year in a situation involving a family member and a disputed property. She said she had his card somewhere and would find it. I told her I appreciated the thought, but that my current attorney was managing the eviction process, and I wasn't sure I needed to add another layer yet. She did not argue with me. She just said she would find the card anyway and leave it on my counter, which she did before she left that afternoon. The independent inspection report came in 2 weeks later. The assessor was a licensed professional with no prior relationship to either party, which was exactly what the court had specified, and his findings were measured and precise. He found no active mold growth in the primary bathroom or anywhere else in the cottage. He noted the presence of minor residual moisture staining consistent with a small plumbing leak that appeared to have been repaired, and he assessed the current condition of the bathroom as within acceptable habitable standards. In plain terms, Sabrina's claim had nothing under it. My attorney submitted the report immediately and requested that the counterclaim be dismissed and the eviction proceeding resumed without further delay. The hearing was scheduled for the following Thursday. I wore the same gray jacket I had worn to every professional meeting I could remember and arrived 15 minutes early, which is a habit I developed on job sites and have never been able to let go of entirely. My attorney was already there. Sabrina's attorney presented a brief argument that the prior moisture damage noted in the inspector's report validated her client's original concern, regardless of whether active mold was currently present. The judge listened, reviewed the submitted documentation, and was notably unenthusiastic about the argument. He did not dismiss the eviction case, and he did not rule in my favor that morning, but he issued a note into the record expressing concern about the evidentiary basis of the counterclaim and scheduled a continued hearing for 30 days out, at which point he indicated he expected a cleaner picture from both sides. It was not a win. I knew enough about legal process by then to understand that a continued hearing with a skeptical judge was a different thing from a ruling, and that 30 more days was 30 more days. But walking out of that courthouse, I felt something I had not felt in weeks, which was that the ground under my feet was at least level, that I was no longer simply absorbing what was being thrown at me, but standing in a place where my documentation, my contractor's report, and my own methodical preparation had held their weight against a manufactured claim. That mattered to me. I wrote it in the notebook that evening with the date, and I noted something else. As well as Sabrina walked past me in the corridor. On her way out, she nodded at me almost pleasantly, the way you might acknowledge someone you expect to see, again, under circumstances more favorable to you. It was the kind of nod that was meant to communicate something. I made sure my face gave her nothing back. The 30 days between that courthouse corridor and the continued hearing were not quiet days. I had learned by then not to expect quiet, not in the way I used to understand that word, as a neutral condition, a resting state between events. Quiet in this situation meant something was happening that I could not yet see, and I had accumulated enough evidence of that pattern to stop mistaking the surface calm for actual stillness. I used those 30 days the way I had been using every available window since March, documenting, cross-referencing, reviewing everything I had collected against everything I was still waiting to understand. I was in the middle of exactly that kind of evening when I found the document that changed the shape of everything I thought I was dealing with. It had arrived in a batch of forwarded mail I had finally managed to have rerouted back to my correct address after filing a formal complaint with the Postal Service about the unauthorized redirection. Some of it was routine, some of it was financial correspondence I had been expecting. And then there was a piece from a private lending institution whose name I did not recognize, addressed to me at the cottage address, which made no sense until I opened it and started reading. It was a pre-approval letter. Not for me. The letter referenced an application that had been submitted by an occupant of the property listing the cottage address as a primary residence of long-term standing. The applicant's name was Sabrina. The loan amount requested was $38,000. In the field of the document marked collateral, the address of the cottage was listed as supporting the application. The letter noted that the application had been reviewed and declined, but the application itself had been filed and processed, and there was now a record of it attached to my property address in a private lender's system. I read it 3 times. Then I set it down, went to the kitchen, poured a glass of water, drank half of it, came back and read it again. She had attempted to borrow $38,000 using my property as a supporting asset, presenting herself as a long-term resident with implied ownership standing. This was not a misunderstanding. This was not an opportunistic move made in the heat of a dispute that had already begun. The mail redirection had started in January. The application, based on the processing date on the letter, had been submitted in February. This had been in motion before I said a single word about wanting the property back. I called Marlene that night and asked her to come over in the morning, which she did, and I walked her through the document the same way I had walked her through the mail records. She was quiet for longer than usual this time. Then she said she thought we needed to stop thinking about this as a landlord-tenant problem and start thinking about it as something else entirely, and I told her I had arrived at exactly the same conclusion somewhere around midnight. She reached into her bag and put a business card on the kitchen table between us. Elias Boone. I had told her 2 weeks earlier that I was not sure I needed another attorney yet. I did not say that this time. I left the card on the table where she had placed it. I called my property attorney first because he needed to know what I had found and because he was still the attorney of record on the eviction case. He listened without interrupting while I read him the relevant sections of the letter, and when I finished there was a pause on his end of the line that told me he was thinking carefully before he spoke. What he said was that what I had just described fell outside the scope of what his practice was set up to handle well. He dealt in landlord-tenant law and notices and hearings and eviction procedure, and he was competent in that lane. What I was describing now involved attempted financial fraud, possibly wire fraud depending on how the application had been submitted, and the deliberate misrepresentation of occupancy status for the purpose of securing credit using property that did not belong to the applicant. He said I needed someone who handled elder financial exploitation and property fraud, someone who could work across civil and potentially criminal dimensions simultaneously. He said he would continue managing the eviction proceeding, but that I should not wait to make that other call. I had barely set the phone down when Marlene, who was still sitting at my kitchen table, told me she had found something else. She had been continuing to research Sabrina's background in the weeks since she found the prior civil matter in the other county's court records, and she had located something new. A paralegal service in a county 2 hours north had a public inquiry record, the kind that gets filed when someone requests forms and procedural guidance, that included a request for information about petitioning for a declaration of incompetency against an elderly property owner. The inquiry was not under Sabrina's name. It was under the name of a woman whose last name matched Sabrina's maiden name, an aunt possibly, or another family member acting as a proxy. The inquiry had been filed in March, 2 months after they moved into the cottage, 1 month before I served the notice to vacate. I sat with that for a long time. She had not been planning to stay indefinitely and wait me out. She had been planning to remove my ability to make decisions about the property at all, to introduce a legal question about whether I was capable of managing my own affairs, to create enough procedural noise around my competency that the property itself would become contested territory while I was busy defending my own judgment in front of a court. My age was not incidental to what she was doing. It was the mechanism. I picked up Elias Boone's card from the table. I turned it over once. Then I called the number on the front. Elias Boone answered on the second ring, which I noted because it was not what I expected from an attorney at that hour, and his voice was the kind of voice that does not waste the first 30 seconds establishing itself. He said his name, asked mine, and then asked me to tell him the situation from the beginning and not to edit it for brevity. So I told him everything in the order it had happened, starting with the phone call in January and moving forward through every piece of documentation I had gathered, every date I had recorded the mail, forwarding the loan application, the prior civil matter. Marlene had found the competency. Inquiry filed under a related name. He did not interrupt me once. When I finished, he asked 3 specific questions about the loan application document, the processing date, and the exact wording of the collateral field, and I answered all 3 from the copies I had in front of me. Then he said he wanted to meet in person within the week and that I should bring the notebook and every document I had. He said one other thing before he ended the call, and I wrote it down immediately after I set the phone down. You have been building your case for months without knowing that was what you were doing. That is more than most people bring me. I had one thing I needed to do before I sat down with Elias. I had been turning it over since the night I found the loan application, and the competency inquiry had settled it for me. I needed to meet with Gavin alone, without Sabrina in the room, without attorneys, without any of the procedural structure that had grown up around this situation, like scaffolding. Not because I thought it would resolve anything legally, and not because I was holding any particular hope about the outcome, but because he was my son and because I needed to know before this moved into territory from which there would be no ordinary return, whether he understood the full scope of what his wife had been doing or whether he had been kept in the dark about the parts that crossed from difficult into criminal. There is a difference between a man who makes a bad choice and a man who participates in fraud, and I needed to know which one I was dealing with before I closed that door completely. I called him on a Wednesday and told him I wanted to talk privately and that I was asking him to meet me without Sabrina present. There was a silence on his end that lasted long enough to tell me he had expected this call eventually. He said he would come to my house Thursday morning. He arrived on time, which surprised me slightly, and he looked like a man who had not been sleeping well, which did not. We sat at the kitchen table, the same table where I had been doing most of my thinking for the past several months, and I did not spend time on preamble. I set the loan application document in front of him, face up, and I watched him read it. He got through the first paragraph and his jaw tightened. He read the collateral field and something shifted in his expression that I recognized, not guilt exactly, but the particular look of a person encountering confirmation of something they had suspected and had been choosing not to examine too directly. He did not look up at me when he finished. He looked at the document for a while longer than he needed to. I told him plainly what I knew: the mail forwarding that started in January, the loan application in February, the competency inquiry filed in March under a name connected to Sabrina's family. I laid it out in sequence the way I would have laid out a site problem for a client who needed to understand the full scope before we could talk about solutions. I was not emotional about it. I was precise. And then I made him a proposition, not because I was afraid of what came next, legally. Because Elias Boone and I were meeting in 2 days and I already knew what direction that was going, but because he was my son and I was willing one final time to offer him a way to step off the path he was on. I told him I would help him find work, connect him with people I knew, give him time to get stable on his own terms. But he needed to tell Sabrina it was over, and he needed to do it now. He was quiet for a long time after I finished. I let the quiet sit there. I had spent enough years managing difficult conversations to know that filling silence too quickly is its own kind of error. When he finally spoke, he did not deny anything I had described. He did not express surprise. What he said was that Sabrina had told him she was trying to secure their future. I asked him whose future exactly he thought was being secured by filing a loan application against a property that belonged to his father. He did not answer that. He looked at the table, and then, in a voice that was quiet enough that I had to hold very still to hear it clearly, he said, "It will be ours eventually anyway, Dad." I looked at my son for a moment after he said that. Not with anger, because anger had largely stopped being useful to me somewhere around the 4th week of this, but with the particular sadness of a man who has just received an answer that closes a question he had been hoping to leave open. I picked up the documents from the table, straightened them against the surface, slid them back into the folder, and stood up. He did not move. I thanked him for coming, and I meant it without irony, because he had given me exactly what I came for, which was clarity. Then I walked him to the door and I closed it behind him, and I went to the kitchen and stood at the window for a while, looking at the yard where Vera's garden used to be, and I let myself feel the full weight of what had just happened before I put it away and started thinking about what came next. The meeting with Gavin on Thursday did something to me that the courthouse hearings and the attorney letters and the manufactured mold report had not quite managed to do. Those things had made me frustrated, then methodical, then quietly determined. The conversation with my son made me tired in a way that sat lower than any of that, closer to the foundation. I had walked into that kitchen with one version of what I hoped was still possible, and I had walked out with a different and permanent understanding of what was not. That is a specific kind of loss distinct from grief, because grief involves something taken from you by forces outside human choice, and this involved choices made by people I had spent decades loving. I did not have a word for it that felt accurate. I just carried it into the following weeks and let it sit where it sat. Elias and I met 2 days after Gavin left, and that conversation was productive in the way that conversations with clear-eyed, prepared people tend to be productive, but I am going to hold that for when it belongs in this account. What came in the days immediately following Gavin's visit was harder. Sabrina had apparently decided around that same period that the legal track she was running was best supported by a parallel effort to shape the public understanding of who the parties in this situation were and what they deserved. I became aware of it gradually, the way you become aware of a smell in a room before you can identify its source. It started with the neighborhood social media group that covered the area around the cottage. I was not a member of it, but Dale was, and he called me one evening to tell me that a series of posts had appeared over the previous week that described in general but recognizable terms a landlord who was attempting to displace a young family. During a period of financial hardship, a man motivated by selfishness and indifferent to the suffering of a child. My name was never used. The details were arranged carefully enough to be deniable as a direct reference, while being specific enough that anyone who knew anything about the situation understood exactly who was being described. The comments beneath the posts were not kind. There were people in that community who had never met me, who knew nothing about me beyond what Sabrina had chosen to present, and they were forming conclusions with the confidence of people who believe they have been given the full picture. I heard similar things from 2 other directions over the following 10 days. A woman who attended the same church as Marlene mentioned to her that she had heard something troubling about a man in the area and a family he was trying to put out of their home. A man I had done occasional business with over the years, a hardware supplier I had used for decades, mentioned when I came in that he had seen something on one of the local Facebook pages and asked carefully if everything was all right. I told him it was being handled. I drove home with the windows down because I needed the air. The lowest point came on a Tuesday in the 5th week after the courthouse hearing. I had driven to the cottage to drop off a notarized document that Elias needed copied from the original on-site for a filing he was preparing. I pulled up across the street and I sat there. I could see Tessa in the front yard moving slowly along the edge of the flower bed Vera had designed. On the south side of the property, not quite playing, not quite doing anything in particular. Just existing in the space the way children do when they are processing something they do not have language for yet. I could hear Sabrina's voice somewhere inside the house, distant and periodic on the phone by the sound of it. The cottage looked the way it always looked in the afternoon light of a Florida spring, which is to say, it looked like itself, unchanged by everything that had happened around it. Patient, the way buildings are patient. I could not make myself get out of the truck. I sat there for close to 20 minutes. Not paralyzed, not afraid, but unable to close the distance between the vehicle and the front door of a house I had built with my own hands on land that belonged to me by every legal and moral measure available. Something about the particular combination of Tessa in the garden and Sabrina's voice inside, and the way the afternoon light was falling, made crossing that driveway feel like an act that required more than I had available at that moment. I set the document on the passenger seat and drove home without delivering it. I told Elias I would bring it by his office in the morning instead. That night I wrote one line in the notebook that I have not read back since. I wrote it, and I meant it in the dark of that particular hour, even though I knew somewhere beneath the exhaustion that it was not accurate. I wrote, maybe I failed him somewhere along the way. Maybe this is just what that looks like 40 years later. I closed the notebook and left it on the table and went to bed. Marlene called at 7 the next morning, earlier than she usually called, and her voice had the particular texture it got when she had found something and had been sitting on it long enough that she needed to say it out loud. She told me she had spent the previous 2 evenings going through every account that had commented on or amplified Sabrina's posts in the neighborhood group, pulling up each profile individually and looking at its history. 3 of them had been created within the past 60 days. No photographs, no personal connections, no prior activity of any kind. Just accounts that appeared at the precise moment they were needed and said exactly what they were needed to say. She had kept going and found 2 more with the same profile created within a week of each other, following no one except Sabrina's public pages. Someone had built an audience from nothing, she said, and then used it to make one person's version of events look like community consensus. Marlene's discovery about the fake accounts was the kind of information that needed to move quickly, and I made sure it did. I called Elias before I had finished my first cup of coffee that morning and told him what she had found, walking him through each account profile the same way she had walked me through them. The creation dates, the absence of history, singular focus on amplifying Sabrina's posts. He listened without interrupting, which I had come to recognize as his way of signaling that what he was hearing mattered, and when I finished, he told me to have Marlene compile everything she had into a single documented summary with screenshots and timestamps and send it to his office by end of day. He said he knew someone who handled digital evidence and that he wanted to move on it before the continued hearing, which was now less than 2 weeks out. The person Elias brought in was a woman who worked in cyber documentation and had testified as an expert witness in civil proceedings before. She took Marlene's compiled summary and ran her own parallel analysis over 4 days. What she was able to establish using device registration data and network identifiers tied to the account's creation signatures was that 3 of the 5 fake profiles had been created from a device associated with a residential address in a county about 90 miles north of the cottage, which was the county where Sabrina's parents lived. She could not establish with legal certainty that Sabrina's hands had been on the keyboard when those accounts were made. What she could establish was a documented geographical and technical connection between the manufactured online audience and a location tied to Sabrina's family. And she could place that finding inside a larger pattern of manufactured evidence that now included the mold photographs with falsified metadata. Taken individually, each piece was arguable. Taken together, they described a person who had a practiced relationship with the construction of false narratives. Elias submitted the digital findings as a supplemental exhibit to the court file ahead of the continued hearing and filed a formal motion requesting that the mold counterclaim be dismissed with prejudice, citing the independent inspector's report, the metadata discrepancy in Sabrina's photographic evidence, and the contractor's inability when Elias's office contacted him directly to produce any original site visit log moisture readings or measurement documentation to support his assessment. The contractor's report, it turned out, had been produced without a recorded site visit that could be verified by any third party. The contractor himself, when pressed through proper channels, provided a response through his own attorney that was carefully worded in a way that suggested he was no longer entirely comfortable with the document he had signed. The judge at the continued hearing did not use the word dismissal, but the effect was the same. He struck the mold counterclaim from the record, noted in formal language that the evidentiary basis had proven unsupportable, and expressed in measured but unmistakable terms his concern about the integrity of documentation that had been submitted to the court. Sabrina's attorney offered a brief response that the judge received with visible patience and then moved past. It was the first time I sat in that courtroom and felt the weight shifting in a direction other than against me. I did not let myself show anything on my face. I had learned by then that the only expression worth wearing in a room like that was no expression at all. What happened in the neighborhood in the days following was something I had not orchestrated and could not have engineered if I had tried. Dale had shared Marlene's findings in general terms with 2 other residents who had lived near the cottage for many years, people who had known Vera and who had been quietly skeptical of Sabrina's account from the beginning, but who had not felt they had grounds to say so publicly. One of them was a retired school teacher named Greta, who had exchanged recipes with Vera for 15 years and who had a reputation in that community for being precise and fair-minded and not prone to involvement in other people's business unless she had something specific to say. Greta posted in the neighborhood group, quote, "Dan Dan Saban Dan Dan." She did not name Sabrina. She did not describe the legal proceedings. She simply stated that she had known the family who owned the property in question for many years, that she had known the man's wife personally, and that the account of events being circulated in the group did not match anything she recognized about his character. She included 2 sentences about the nature of verified information and the responsibility people carried when they amplified claims they had not personally witnessed. The post was calm and specific, and it landed the way a precisely placed statement lands when the person making it has genuine credibility in the room. The comment section beneath Sabrina's posts went quiet within 24 hours. I heard about Greta's post from Dale, who read it to me over the phone while I was in my driveway one evening, and I sat with it for a moment before I said anything. Then I asked Dale to pass along my thanks to her in whatever way felt natural, without making it seem like something I had asked for, because I had not, and I did not want it framed that way. It mattered that it had come from her without my involvement. That was exactly what made it worth something. The day after the continued hearing, Elias called me and asked me to come into his office. Not to debrief on what had happened in court, but because he wanted to talk about something larger. When I sat down across from him, he set his legal pad on the desk, looked at me steadily and said, "Warren, you have been fighting the wrong war. Eviction law is slow and they know how to work it, but what she did with that loan application is federal territory. That changes everything about how we proceed from here. Federal territory." I let those two words settle in the room for a moment before I responded, because they carried a weight that I wanted to make sure I was receiving accurately before I said anything back. I had spent months thinking about this situation in terms of property rights, tenancy law, eviction procedure, the slow machinery of landlord-tenant disputes in a state that took its time with such things. Elias was telling me that I had been operating inside the wrong frame entirely. Not because the eviction case was invalid, but because what Sabrina had done extended well beyond the boundaries of a rental disagreement into territory governed by a different set of laws with a different set of consequences. I asked him to walk me through it from the beginning, and he did. The loan application was the center of it. When Sabrina submitted that document to a private lender using my cottage address as her primary residence and listing the property as collateral, she had made several representations that were materially false. She was not a primary resident in any legally recognized sense. She had no ownership interest in the property. She had no authority to pledge it as collateral for anything. The fact that the application had been declined did not eliminate the fraud. The application had been submitted. It had been processed. It existed in a lender's system tied to my property address. Elias explained that depending on how the application had been transmitted, whether electronically or through the mail, it potentially triggered wire fraud or mail fraud statutes at the federal level, in addition to state-level financial fraud claims that his office was fully equipped to pursue civilly. He said he was going to file a civil complaint that week and simultaneously notify the Florida Office of Financial Regulation, which would trigger a parallel administrative inquiry. He said these two tracks together would create a different kind of pressure than a continued eviction hearing, the kind that Sabrina's current attorney was not set up to manage. He also told me about the mail redirection. I had understood it as a troubling detail, a piece of premeditation that indicated planning. Elias understood it as an additional, actionable offense. Redirecting another person's mail without authorization is a federal matter, full stop, and the fact that it had occurred before any overt conflict between us, before any notice had been served or any dispute had been documented, placed it firmly in the category of premeditated conduct rather than reactive behavior. It showed intent. It showed that the plan had been operational before I had any reason to suspect one existed. He said this detail properly documented and presented in context with the loan application timeline constructed a portrait of deliberate sequential financial exploitation that was difficult to characterize as anything other than what it was. I brought the notebook to that meeting, all 87 pages of it, and I watched Elias go through it section by section with the focused attention of someone reading a document that is going to become part of a legal argument. He paused at several entries, made notes of dates, flagged the pages where I had recorded Sabrina's exact words in quotation marks. When he finished, he looked up and said that I had done something most people in my situation did not do, which was create a contemporaneous record of events as they unfolded with dates and specific language that would be substantially harder to challenge than a reconstruction assembled after the fact. He said the notebook would be submitted as a formal exhibit. I had started keeping it because it was what I knew how to do from 40 years on job sites. I had not known then that it would become the spine of a legal case. But it had, and he wanted every page of it. His investigator had already been at work on Sabrina's background before I arrived at that meeting building on what Marlene had originally found. The sealed civil matter from 6 years earlier had been examined more closely. The investigator had located the original landlord, a man in his late 60s, who had filed and then withdrawn the eviction claim and had spoken with him informally. The man had not wanted to go into detail. He had used the word settlement twice and had said he did not see any benefit in revisiting the situation. But the pattern of what he described in general terms before he stopped talking was recognizable. A tenancy that began with apparent goodwill, a gradual shift in the occupant's behavior. As months passed, a claim of property interest that, emerged after a dispute began, and a resolution that had cost him time, money, and considerable stress. Different address, different state, same architecture. Elias told me he was going to file the civil complaint by Thursday. He was also going to submit a formal notification to the state attorney's office with a summary of the evidence and a recommendation that the matter be reviewed for potential criminal referral. He said he could not control the pace of a criminal inquiry, that these things moved on their own timelines, but that the notification itself would be part of the record and would signal to everyone involved that this had ceased to be a private landlord-tenant matter and had become something with a broader audience. I drove home from that meeting with the windows down again, but this time it was not because I needed air to manage something difficult. It was because the evening was genuinely pleasant, and I had not noticed the weather properly in a long time. I had just turned onto my street when my phone rang through the truck speakers. It was Elias calling from his office less than 40 minutes after I had left it. He said his assistant had just forwarded him something from the lender inquiry they had opened as part of the civil complaint preparation. He said he needed me to hear it directly. Sabrina had submitted a second loan application the previous week. Different lender, same collateral, the cottage. It had also been declined. But she had tried again after the court hearing, after the mold counterclaim had been struck from the record, after everything that had happened in that courthouse corridor. He let that sit for a moment and then said, "She does not know we are coming. She does not know we are coming." I had written that line in the notebook when I got home that night, not as a boast and not as a threat, but as a factual statement about the current state of information between two sides of a situation that had been moving for months. Sabrina had been operating with the assumption that she understood the full scope of what she was facing. She had seen the eviction case, the continued hearing, the mold counterclaim that had not held. She had adjusted her approach, tried the second loan application, kept her social media presence active. She was running the same playbook with minor variations because from where she was standing, that playbook still appeared to be working. What she did not know was that the ground she was standing on had been fundamentally reclassified, that the legal effort now aimed at her was not an eviction proceeding that could be delayed and maneuvered around, but a civil fraud complaint with a parallel administrative inquiry and a notification sitting in a state attorney's Ponz's office waiting for a reviewer to open it. The distance between what she thought was happening and what was actually happening was the most significant tactical advantage I had held at any point in this. And Elias and I had agreed without much discussion that we would not be the ones to close it prematurely. The change in Sabrina became visible from the outside before I understood its source. Dale noticed it first, the way he noticed most things in that neighborhood, with the patient observation of a man who spent time on his porch and paid attention to what moved around him. He called me on a Wednesday to mention that Sabrina's behavior had seemed different in the past 10 days or so, less composed than he was used to seeing from her. She had deleted and reposted the same content on her social media pages multiple times, he said, and the tone of what she was putting up had shifted in a way he found hard to describe, exactly swinging between something that sounded defiant and something that sounded like a person explaining herself. To an audience she was no longer confident was fully on her side. He had also seen lights on in the cottage past midnight 3 nights in a row, which was unusual for a household with an 11-year-old. I understood what I was observing when Elias explained it to me a few days later. The Florida Office of Financial Regulation had sent a standard inquiry letter to the address on record for the loan application, which was the cottage address. Sabrina had received it. She did not yet know the full scope of what had been filed or what it connected to, but she knew an inquiry had been initiated, and she knew it was tied to the loan application, which meant she knew someone had found it and reported it. The controlled, methodical version of Sabrina that had managed this situation with such careful precision for months was now operating under a form of pressure she had not anticipated, and pressure applied correctly to a person who has built their position entirely on the management of appearances tends to produce exactly the kind of fractures Dale had been observing from his porch. What it produced inside the cottage, I learned later, was a version of Sabrina that Gavin had apparently not encountered before in quite this form. She began pushing him hard to intervene, to contact me directly, to find some avenue that would make the inquiry go away, or at least slow its momentum. Gavin had no such avenue, which she likely knew, but knowing it did not appear to reduce the pressure she was applying. Their daughter was in the house for all of it. Tessa was 11 years old, and she was not a child who missed things that happened in the rooms around her. I already knew that from the garden book she had saved in the basement and the careful way she had watched the world from the moment I first noticed her. What I did not know until that afternoon was how much she had been carrying quietly and for how long. I had driven to the cottage to drop off a document for Elias, something that needed to be photographed against the physical property address for a filing he was preparing. I parked at the curb and was walking toward the mailbox when I heard my name. Not the sound of it called from a distance, but said quietly, "Close the way you say someone's name when you are already standing near them." I turned and Tessa was on the sidewalk about 10 feet away alone. No jacket, despite the afternoon being cooler than it looked. She was watching me with an expression that was too composed for a child her age, the kind of composure that gets built by spending time in rooms where composure is the only option available. She said "Grandpa," and it was the first time I had heard that word from her in a way that sounded like she was claiming it rather than just using it. I did not move toward her quickly or make any gesture that might have startled her back. I just stopped where I was and waited, and she came a few steps closer and looked at me and said she needed to tell me something. I told her I was listening, and I meant it the way I had meant few things in the previous months. She said she had seen Sabrina putting papers into a blue folder, the kind with a metal clasp on the front, and locking it in the filing cabinet in the back bedroom. She said she had heard Sabrina on the phone one night saying that everything was in there, that if anything went wrong it documented what they had planned from the start. She said her mother had told her afterward that the folder did not exist and that Tessa had imagined it. She looked at me when she finished and said she knew she had not imagined it because she had touched it herself. I stood on that sidewalk for a moment after Tessa finished speaking, and I did not say anything right away because there was nothing to say that would have been adequate to the weight of what she had just done. She was 11 years old, and she had walked out of that house and found me at the curb and told me the truth about something her mother had instructed her to deny, and she had done it alone, without anyone telling her to, because she had decided on her own that it needed to be said. I thought about the garden book in the basement and the careful way she had placed it where it would not be thrown away, and I understood that this child had been making quiet decisions about what deserved to be protected for longer than I had known. I told her she had done the right thing. I told her she was not in trouble, and that I was glad she had told me. I did not ask her for anything more than what she had already given, and I did not put her in the position of saying anything further about her mother that she would have to carry. I asked if she was cold, and she said a little, and I walked her back to the front path and watched her go inside, and then I got in my truck and called Elias before I had driven half a block. He listened to everything I told him about the conversation with Tessa, and when I finished, he asked 2 clarifying questions, both about the physical description of the folder and the specific language Tessa had heard Sabrina use on the phone. Then he told me he was going to move that day. The civil fraud complaint he had already filed gave him grounds to pursue a formal discovery order compelling Sabrina to produce all documents in her possession related to the property, its occupancy, and any financial instruments connected to the cottage address. A blue folder containing planning documentation would fall squarely within the scope of that order. He said he would have the motion filed by end of business, and that he expected it to be granted given the existing evidentiary record the court had already received. The order came through in 4 days. Sabrina's attorney had the weekend to respond, and the response they filed was a brief procedural objection that the judge reviewed and declined to sustain. The production deadline was set. On the specified date, Sabrina's attorney delivered a packet of documents to Elias's office, including a blue folder with a metal clasp on the front, which was described in the accompanying inventory as containing internal household planning materials. I did not learn until later that Sabrina had apparently believed, or had been advised to believe, that what the folder contained was either too vague to be actionable or had been sufficiently edited before production to reduce its impact. She was wrong about both of those things. Elias called me the afternoon he received the production and asked me to come to his office the following morning. When I sat down across from him, he had the folder open on the desk between us, and he walked me through its contents methodically, the way he walked through everything without drama in sequence, letting each item establish its own weight. The first document was a printed checklist with a handwritten title at the top that read, "Property Transition Steps." It had 7 items on it. Transfer utilities to occupant names. Establish school enrollment at property address. Document primary residency through institutional correspondence. Research loan instruments available to long-term occupants. Assess competency challenge framework and timeline. Identify legal representation familiar with adverse possession adjacent claims. Secure all original property documents accessible at site. 6 of the 7 items had a small checkmark beside them in blue ink. The 7th, the one about securing original property documents, had a question mark. I read the list twice. Then I looked up at Elias and he nodded once, which was his way of confirming that I was understanding it correctly, and turned to the next document. It was the incompetency petition research I had known about in general terms since Marlene found the inquiry record months earlier, but seeing it printed and organized was different from knowing it existed. There were notes in the margins in Sabrina's handwriting, references to specific filing procedures. A circled passage about the evidentiary standard required to initiate a capacity review for a property owner over 60. Then Elias turned to the last item in the folder. It was a single printed email, the kind you print because you want a physical copy of something you consider important enough to preserve. The date on the email was 11 days before the phone call in January when Gavin had told me he and Sabrina had nowhere to go. The recipient was a woman whose name I did not recognize. The body of the email described the plan in terms that were direct and specific: the cottage, its assessed value, its location, the age of its owner, the expected timeline for establishing occupancy standing. In the middle of the second paragraph, Sabrina had written that Gavin was useful but limited, that he did not fully understand the plan, but would go along with it if the framing was handled correctly. Near the end, she had written that her goal was to establish occupancy rights strong enough to support a challenge to sole ownership before the subject had grounds to respond effectively. Elias read that paragraph aloud to me slowly. Then he set the page down. The room was quiet for a moment, and I let it be quiet. Then I asked him one question. I asked whether he thought Gavin had known she wrote it. Elias looked at me steadily and said he did not believe so, and that he thought when Gavin saw it, which he would, that was the moment the entire structure Sabrina had built would begin coming apart from the inside. He closed the folder and placed both hands flat on the desk and said, "Warren, I am recommending we forward this to the state attorney's office today. But first we have a hearing in 11 days. And I want her to walk into that courtroom believing she is still ahead." The 11 days between that meeting in Elias's office and the hearing were the most deliberately quiet 11 days I had spent in the entire length of this situation. Not quiet because nothing was happening, because a considerable amount was happening on the legal side: filings, submissions, the forwarding of materials to the state attorney's office, the preparation of an evidence package that Elias's team had been assembling with the care of people who understood they would only get one opportunity to present it in the way it needed to be presented. Quiet on my end, specifically by choice and by instruction. Elias had asked me not to contact Gavin, not to drive past the cottage, not to engage with anything Sabrina posted or said through any channel. He wanted the next thing she heard from our side to be whatever she heard when she walked into that courtroom. I honored that completely. I stayed home, worked in the garden Vera had designed, finished a small woodworking project I had started in February, and abandoned when the situation became too consuming to leave room for anything else. I slept reasonably well most nights, which surprised me. I think my body understood that the preparation was done, and that what remained was simply to show up. The morning of the hearing, I wore the same gray jacket I had worn to every court appearance. I arrived 17 minutes early and sat in the hallway outside the courtroom with my notebook in my lap, not reading it, just holding it. It had been with me through every development in this situation, and it seemed right that it was there at the end of it. Elias arrived 12 minutes before the scheduled time and sat beside me briefly. Reviewed 2 points he wanted me to be clear on regarding the sequencing of exhibits, and then went inside to arrange his materials. I followed a few minutes later and took my seat. Sabrina came in with her attorney 4 minutes before the start. She was dressed carefully in the composed and deliberate way she dressed for every public appearance I had seen her make, and she carried herself with the particular posture of someone who has convinced themselves that their version of a situation is the one that will prevail. Gavin was beside her. He looked like a man who had not eaten properly in several weeks. He did not look at me when he came in. He sat down and fixed his eyes on the table in front of him and kept them there. Sabrina's attorney opened in the same register he had used at the previous hearing, framing the case as a tenancy dispute involving a family in good standing, a verbal agreement that had been honored, and a landlord whose conduct had become increasingly erratic and intimidating. The judge listened with his hands folded on the bench and his expression offering nothing. I had sat across from that expression twice before, and I had learned to read its neutrality as attention rather than indifference. He was receiving everything and releasing nothing, which was exactly what I wanted him to be doing. Elias presented in sequence. He did not raise his voice at any point, and he did not editorialize. He simply moved through the timeline item by item, placing each exhibit into the record with a brief, precise explanation of what it represented and where it fit in the larger pattern. The mail redirection with its dates. The loan application with its processing date and its collateral field. The second loan application filed after the prior court hearing. The metadata from the mold photographs, showing the fabrication of the timeline Sabrina had submitted as evidence. The checklist from the blue folder read aloud in full, each item delivered in the same measured tone, each checkmark noted. The research on the competency petition framework placed into context with the prior inquiry Marlene had located months earlier. Sabrina's expression did not change visibly through most of this. She had prepared for a version of this hearing that she believed she could manage. She was recalibrating in real time, and she was doing it without showing it, which I recognized as a skill she had developed through long practice. Then Elias introduced the email. He read it aloud the way he had read it to me in his office, slowly and in full, without emphasis, letting the words carry themselves. When he reached the passage about Gavin being useful but limited, not fully understanding the plan, I did not look at Sabrina. I looked at Gavin. He had gone completely still, in the way that a person goes still when something external confirms something internal that they had been refusing to fully examine. He was reading along on the document copy that had been distributed to all parties. I watched him find the line about himself. I watched him read it twice. He set the page face down on the table with a careful, deliberate motion, and he did not pick it up again. Sabrina's attorney cross-examined on the timeline, pressing on the question of whether the loan application represented intent to defraud or an exploratory inquiry made under a mistaken understanding of occupancy rights. Sabrina answered questions in a composed voice until Elias's redirect established, using her own prior written statements, that she had understood the property's ownership status clearly before the application was filed. The contradiction in her timeline became visible and then unavoidable, and the courtroom registered it in the particular way that courtrooms register things, a shift in the quality of the silence. Gavin asked to address the court. His attorney placed a hand on his arm. He spoke anyway. He said the email was authentic. He said he had not known about the loan applications. He said that the original call to Warren in January had been made at Sabrina's direction, using a framework she had prepared in advance, and that he had believed at the time that he was asking his father for help. He said he understood now that was not what she had been asking for. His voice was steady throughout. He sat back down. Sabrina did not look at him. The judge called a recess. When court resumed, he stated on the record that the court had received substantial evidence of fraudulent intent with respect to the property in question, and that a full ruling would be issued within 5 business days. I walked out of that building into the afternoon light and stood on the steps for a moment. I did not feel triumphant. I felt the specific relief of a man who has been carrying something heavy for a very long time and has just been permitted finally to set it down. The ruling came on the 4th day, 1 day earlier than the judge had indicated, and Elias called me at 8 in the morning to read the relevant sections to me over the phone. I sat at the kitchen table with my coffee and listened to the language of it, the formal, precise language that courts use when they have reached a conclusion and want the record to reflect exactly what they found and why. The judge had ruled in my favor on the eviction proceeding, ordered the immediate vacating of the property, and formally referred the matter to the state attorney's office for review of the loan application filings under applicable fraud statutes. There was additional language about the integrity of documentation submitted during the proceedings, language that Elias said was notable for its directness given the typically measured register of judicial rulings. I thanked him. I set the phone down on the table. Then I sat there for a few minutes without doing anything in particular, just letting the fact of it settle into the room around me. The enforcement was scheduled for a Thursday morning, 8 days after the ruling. Sheriff's deputies handle the physical enforcement of eviction orders in Florida, which I had known from my conversations with my property attorney months earlier, and the process is exactly as formal and procedural as it sounds. 2 deputies would arrive at the property with the court order, present it to the occupants, and oversee the vacating of the premises. I was advised to be present but to remain at a distance from the structure itself during the enforcement, which I had already decided on my own. I was not going to stand on that porch while it happened. I was going to stand at the end of the driveway far enough back to give the process room to work close enough to see it through to the end. Thursday was clear and warm, the kind of Florida morning that does not announce itself with any drama, just arrives with light and stillness and the sound of birds in the tree line. I got there before the deputies and parked across the street. My hands were steady. I had not expected them to be unsteady, but I noted it anyway, the way I had been noting things for months as information worth recording. The deputies arrived at 8:15, 2 of them professional and unhurried, and they walked to the front door and knocked. There was a pause of perhaps 2 minutes before the door opened. Sabrina stood in the doorway and read the enforcement order without speaking. She held it for longer than she needed to, the way a person holds a document when they are processing not its content, which they already understand, but its finality. Then she turned and went back inside. Gavin came to the door next. He looked across the yard to where I was standing at the end of the driveway, and for a moment we were looking at each other across a distance that was longer than the width of that property. He did not say anything. He went back inside and started bringing out boxes. Tessa came to the door once while Gavin was making one of his trips to the vehicle they had parked in the driveway. She stood on the threshold and looked across the yard at me, and I raised one hand, palm out, not a wave, exactly more an acknowledgement. She raised hers back. Then she went inside and I did not see her again that morning. It took them a little under 2 hours. When the last box was loaded and the deputies had completed their walkthrough and confirmed the property was vacated, one of them came to the end of the driveway and told me the premises were clear and handed me the documentation confirming enforcement. I thanked him. I waited until both vehicles had left the street before I walked up to the front door. I went to the basement first. The boxes I had seen on previous visits, the ones containing Vera's photographs and her garden book, and the other things that had been moved down there in the first weeks of the occupancy, were still stacked against the far wall. I carried them up myself one at a time, making as many trips as it took, and I set them in the living room. I unpacked the wedding portrait and carried it to the mantel and set it back in the place where it had always been, where the light from the south window reached it in the late afternoon and made it look the way it had always looked when Vera was alive to see it there. I stood in front of it for a while. There was a lot I could have said. I said some of it quietly to the room and the light and wherever she was in relation to either of those things. Then I walked to the kitchen and I called the Florida Office of Financial Regulation directly myself, without waiting for Elias's office to manage it on my behalf. I had the confirmation number from the complaint filing already logged in the notebook. I worked through the automated system, reached a representative, provided the case reference, and formally submitted the additional documentation that Elias had prepared, including the second loan application and the blue folder checklist, as a supplemental filing to the open inquiry. The representative gave me a new confirmation number. I wrote it in the notebook with the date and the time and the name of the person I had spoken with. That was when I saw it. On the kitchen counter near the back edge was a folded piece of paper that had not been left by accident. I recognized the handwriting before I fully registered what I was reading. It was Sabrina's and it said, "Once he is out of the picture, this place is ours." Step 1, residency. Step 2, financial. Step 3, capacity challenge. Timeline, 18 months. It had been separated from the blue folder at some point and she had left without it. And it was sitting on the counter of my kitchen in my cottage, as though it had been waiting for me to find it. I photographed it with my phone, noted the date and time in the caption, and added it to the file. I added the note from the counter to the case file that same evening, and forwarded the photograph to Elias with a brief message explaining where and how I had found it. He responded within the hour 2 sentences, saying it had been added to the supplemental submission and that he hoped I was getting some rest. I read that last part twice. It was the closest thing to a personal remark I had received from him in the months we had worked together. and it landed with the particular warmth that understated things carry when they come from people who are not in the habit of saying more than they mean. The weeks that followed the enforcement moved at a different pace than the months preceding it, slower in some ways, more deliberate, like a tide going out after a long time coming in. The Florida Office of Financial Regulation opened a formal investigation into the loan applications within 10 days of receiving the supplemental filing. I received a written confirmation of the inquiry status in the mail addressed correctly to my main house, which I noted without irony and filed in the accordion folder alongside everything else. Elias told me the state attorney's office had assigned a reviewer to the criminal referral and that the process would take the time it took, that these things did not move on anyone's preferred schedule, but that the documentation we had provided was thorough, and the referral had been accepted rather than declined, which was the first meaningful threshold. The social media presence Sabrina had spent months building, the lifestyle account, the posts about healing and home, and the cottage she had called her little piece of paradise went quiet within 2 weeks of the hearing. The account was made private shortly after that, and then it disappeared entirely. The neighborhood group returned to its ordinary rhythms, yard sales and lost pets and weather advisories, as though the other thing had simply passed through and moved on. Gavin did not call. The silence from his direction lasted 6 weeks before anything arrived, and when it did, it was a letter handwritten, 3 pages, sent to my main house address. I sat at the kitchen table and read it twice all the way through, both times without stopping. He said things in it that I believed and things that I was not yet in a position to receive, and the combination of those 2 categories was more complicated than simple anger would have been, which is perhaps why he had chosen a letter over a phone call. A letter does not require an immediate response. It asks only to be read. I folded it back along its original creases and put it in the drawer of the side table by the kitchen door, the same drawer where I kept things I was not ready to discard but was not ready to act on. I did not write back that week or the week after. I was not punishing him. I was not performing indifference. I was simply not available on a timeline that someone else had set, and for the first time in as long as I could remember in relation to my son, that felt like the right posture rather than a failure of something. The card from Tessa came on a Saturday in an envelope addressed in the careful block letters of a child who has been taught that handwriting matters. It was a plain card with a bird on the front, a cardinal, which I suspected she had chosen because she had seen enough of Vera's things to know that cardinals had meant something in this house. Inside she had written, "I am glad you got your house back. I always knew it was yours." She had signed it with her first name and a small drawing of what appeared to be a flower, though it might have been a sun. I read it standing at the kitchen counter, and then I read it again sitting down. I did not frame it on the mantel or put it somewhere prominent in the main house. I took it to the workshop behind the cottage and tacked it to the wall beside the window, where I do most of my detail work, where the light is good and steady through the morning hours. That felt like the right place for it. Close to where the work happens. Close to where things are made to last. I moved into the cottage in the 3rd week after the enforcement. Not as a temporary measure, not as a statement, but because it was what I had planned to do, and the plan had survived everything that had been thrown at it, and I saw no reason to delay it further. I brought what I needed and left what I did not, and I spent a weekend putting things back in the places Vera and I had originally chosen for them, which took time because we had chosen carefully, and I wanted to honor that care. The south window light in the late afternoon still fell exactly the way it always had. The porch was wide enough for 2 chairs with room between them. The morning came across the property from the east, just as she had said it would, soft and unhurried, the kind of light that did not ask anything of you before you were ready to give it. I was sitting on that porch on a Tuesday morning, several weeks after I moved in, coffee in hand, watching the early light work its way across the yard when I thought about the sign. Not the one that had been mounted on the post when I arrived that afternoon months ago, the one with a name that was not mine. My own sign. I had been thinking about what it would say, and I had decided it would say very little, just the house number and 1 word beneath it. The same word that had been on the deed since the day I filed it, the same word that had been true through every motion and every hearing and every manufactured claim that had been built and dismantled over the previous months. I had the cedar already selected in the workshop. I had the tools I needed. I knew how long it would take and what it would look like when it was finished, because I had been building things long enough to be able to see the completed version before I make the first cut. I did not take anything from them. I did not chase them or destroy them. or ask anyone to feel sorry for what they had attempted or for what it had cost them when it failed. I built a case the same way I have built everything in my life, one documented detail at a time, with patience and without flinching. And I stood on the correct side of every decision available to me, and I waited for the truth to do what the truth does when it is properly supported. What I got back was not only a house, it was the proof that I was still here, still standing, and still exactly who I had always been. That is worth more than any property. That is the thing they never had any hope of taking, even when they thought they were closest to it. If this story stayed with you, I want you to know it stayed with me too, and not simply because of the deception or the courtroom or the months of quiet endurance it took to get to the other side of it. What I keep returning to is Warren, and specifically what Warren never stopped doing, even in the moments when everything felt stacked against him. He did not wait for someone to rescue him. He picked up a notebook and started writing things down. That single decision, made at a kitchen table on an ordinary evening, became the foundation that held when everything else was being challenged. That is the part of this story I want you to carry with you. Here is what I believe this story is asking all of us to consider. If you own property and someone is living in it under any arrangement, even one built entirely on trust and family feeling, please put it in writing. A signed agreement is not an insult to the relationship. It is a protection for both people in it. If something about a situation feels wrong before you can name exactly why, start documenting it immediately with dates, with specific language, with copies stored somewhere safe. Do not dismiss your instincts because the person making you uncomfortable is someone you love. And if you are ever facing something that has moved beyond what feels manageable alone, find the right professional help, and find it before the situation becomes harder to untangle. Warren survived this because he paid attention, he documented everything, and he refused to disappear quietly. You deserve that same standing. Thank you for watching this all the way through. If this story meant something to you, please share it with someone who needs to hear it today.